So we are the legal team at Core, and my name is Navraj Ghali, and I lead the legal and regulatory work packages at Core, and I'm a lawyer and based at the University of Edinburgh Law School.
Yes, I'm Marcely Van Looy, and I'm also a lawyer based at the University of Edinburgh Law School. And I'm a researcher for the legal work package at Core, focusing on regulatory review of greenhouse gas removals.
The GGR world, obviously, is very new, and one of the key problems is that industry and regulators often don't know what the rules are. These are legacy rules from other applications and other problems. And so navigating through that has been something that has proved to be very challenging for people on the ground.
The report was all-encompassing of many different types of GGR throughout the UK. So we covered biochar, enhanced rock weathering, BECCS, DACs, afforestation, peatland and marine. So it was very wide-reaching, and it covered all 4 of the jurisdictions in the UK. And the findings varied very much from the more holistic, kind of all-encompassing findings that were common across GGRs and jurisdictions, all the way through to some more specific points. Do you want to touch upon waste law, for example?
Yeah, sure. So waste law is a really well-developed area of law with all sorts of applications in industry and agriculture. And what a lot of the demonstrators have found, in particular biochar and peatland, is that in order to undertake GGR work, you very quickly get run up against waste law, which has got provisions on how much, say, biochar you can apply on a piece of land and what has to happen to it and how you monitor it and so on. And the regulations are really tight because they're designed for a different purpose. They're, say, designed for agricultural or fertilizer uses, whereas biochar has different characteristics, but it's still regulated in that very tight way. So overcoming those sorts of difficulties was something which was useful for the biochar, the peatland communities, and basically any land-based GGR technology.
So if I can go back to that, the more encompassing findings of the ones that are relevant to all GGRs and all jurisdictions, something that we came across time and time again is that relationship between regulators and industry and what each needs from the other in order to support scaling of these technologies. And so this is a kind of loop between them that we've coined this regulatory paradox, whereby one side is the kind of regulators are needing this evidence to overcome risk and to meet their legal mandates. And on the other side, industry sometimes struggles to provide that evidence, partly because of a lack of regulatory support. And so that it kind of goes round in a circle like that. So there are various suggestions going around at the moment from kind of sources like the Corrie Review, for example, such as regulatory sandboxing and how we can provide a more flexible regulatory environment for these projects to test out their technologies in a time-limited fashion with reduced risk.
So one of the things that's needed in order to overcome the problems which Marcely just identified is much closer co-working between government and industry, specifically on these sorts of problems, to overcome that regulatory paradox so that both sides have the information that they need. But also working within government. We're finding that there are different central government departments working on parallel issues that don't necessarily engage with one another as in a detailed a fashion as they might do, but also across the United Kingdom, devolved governments are working on all of these things with varying degrees of focus and resource and knowledge sharing between them. So that sort of working between levels and types of governments and industry would be really valuable.